Hello and welcome. My name is Veronica Norgaard. I'm a licensed attorney in the state of New Jersey with the firm of Weinberger Divorce and Family Law Group. I've been practicing family law for the past 16 years. With me today is Rachel Partyka, another attorney with Weinberger Divorce and Family Law Group, who has also been practicing for 16 years. We are here today to discuss with you military parents in New Jersey and their rights and responsibilities. Our disclaimer, as always, is that this presentation contains general information and does not constitute legal advice. Please make sure to speak to your attorney if you have any specific questions. Weinberger Divorce and Family Law Group is not affiliated with the U.S. military. We will be talking about a few areas today regarding military parenting in New Jersey and their rights and responsibilities. These will include introduction and common procedural issues, child custody and parenting time, child support, and military benefits for children. So Rachel, do state courts enforce military branch policies or do they make their own orders?
So Veronica, state courts abide by state law, okay? And while each branch of the military may have some regulations and policies in place, which I will get into in more detail as we move forward with our presentation, ultimately what you need to remember is a lot of times military guidelines will apply if there is no state court order or other agreement between the parties. But once the state courts become involved, state court orders always control.
Can issues involving child custody and visitation become more complicated for military divorces?
Yes, they can. And you know, we just talked about a little bit about why that is, but we also have an added layer in that military families often move around a lot. And the frequent moves sometimes result in confusion about what state is the appropriate state to handle these issues. And that state can change as people move around.
In New Jersey, where would one file for custody, visitation, or child support?
So when we've got service members living in the state of New Jersey, we have some options with regard to where we file. First of all, we need to look at where the child resides. If the child is residing here in New Jersey and no other court has ever entered an order with regard to that child, then the courts in New Jersey are the appropriate jurisdiction. Okay, jurisdiction is what gives the court an authority to make decisions in any given matter. Okay, so if we have two parents and a child all residing in the state of New Jersey, jurisdiction lies in New Jersey. We rely upon the state court in New Jersey to deal with any claims involving custody, parenting time or visitation, and child support. Okay.
So what law is followed to determine jurisdiction? Is there a separate law with regard to custody or with regard to child support?
We have two laws, one that deals with custody and one that deals with child support. The law that controls jurisdiction with regard to custody is the UCCJEA, which is the Uniform Child Custody Jurisdiction and Enforcement Act. And jurisdiction in child support matters is controlled by UIFSA, the Uniform Interstate Family Support Act.
So let's talk a little bit more about the Uniform Child Custody Jurisdiction and Enforcement Act, also known as what you said, UCCJEA. So under the UCCJEA, what are the circumstances that a state can claim jurisdiction of a child for child custody and visitation?
So there's several circumstances under which any given state can claim jurisdiction. The first is whether or not that particular state is considered to be the child's home state, which is defined as a state where the child has resided for at least 6 months or more. Now, oftentimes we're dealing with children who are younger than 6 months, in which case we look at the state where the child has resided for most of their life or where they're presently residing. The reason for this is that it's in the best interest of the child for all of these issues to be handled in a jurisdiction that has significant connection to this child, meaning the child is either physically present in the state or has been physically present until recent time. In addition, the UCCJEA allows for the court in any given state to take jurisdiction if a child has been abandoned within the state or if they're in need of emergency protection. And lastly, if we have a situation, like I mentioned a few moments ago, where we have a child who's less than 6 months old, perhaps, or another circumstance in which no other state actually has jurisdiction over a child, and the court determines it's in the child's best interests, any court, including New Jersey, can take jurisdiction over that child.
Now, if a child is a U.S. citizen, is it possible that a foreign country could have jurisdiction of that child?
So, if a child is a citizen of the United States, technically, a foreign country could potentially have jurisdiction over that child. But then we need to consider whether or not that's a temporary situation. For example, and specifically with regard to military families, oftentimes we may have a family that's deployed overseas for a period of time, in which case we know the family is returning and New Jersey will continue jurisdiction.
Now, let's talk about a little bit about the Uniform Interstate Family Support Act, also known as UIFSA. This is the law that we follow if it's regarding support orders, correct?
That's correct. And when we talk about Uniform Interstate Family Support Act, this tells us which court has the ability to enter child support orders against any payor.
So there's a payor, or is there well, who's the obligor in a support matter? Is that the person who's paying?
That is the person is paying, and they're oftentimes also referred to as the payor. And the person who's receiving the support is considered the obligee or the payee.
Does the state have to have personal jurisdiction over the obligor?
Absolutely. A state court cannot enter a child support order against a payor if they don't have jurisdiction over that person.
Okay. For both the UCCJEA and UIFSA, can more than one state have jurisdiction?
No, only one state can exercise jurisdiction at any given time over any particular issue. It is possible, however, to have two different states who have jurisdiction for different purposes. For example, if we have a service member living in the state of Florida, Florida would have jurisdiction with regard to support actions under UIFSA. Under the UCCJEA, however, if the child is residing here in New Jersey, New Jersey has jurisdiction over that matter with regard to issues involving custody and parenting time.
Will other states enforce orders?
Absolutely.
And will they also modify orders?
Other states can only modify orders if they're consistent with the law in the original issuing state. For example, if parties have entered into a particular order in the state of Connecticut, and then for whatever reason New Jersey then has jurisdiction over this matter, there are certain circumstances under which the New Jersey court may modify an order, but may only do so consistent with the laws of the initial issuing state. We often see this in issues involving emancipation, termination of child support, contribution to college expenses, oftentimes with regard to UIFSA and family support type actions. Otherwise, a secondary state really doesn't have the ability to modify orders.
So when we're filing an application in state court, must you give notice to the other parent?
You absolutely do. Nothing can be done unless the court is satisfied that the other party has been provided with sufficient notice of what's happening.
And how can that notice be provided?
In New Jersey, we can provide notice via mail, regular and certified. When we send certified mail, we request a return receipt so that we can provide proof to the court that it's actually been mailed and received. In addition, when we're specifically talking about service members, we've got to consider, where that person is residing. Sometimes it's possible to serve that party via mail. And, we can also serve them at their residence if they live off base. But it's important to remember that non-service members and non-family often do not have access to base. And so if we need to serve someone on base, we need to contact the commanding officer or the provost marshal on that base and follow their instructions.
What about parents overseas? How do they get notice?
That can be more difficult and more challenging. If we know that somebody is going to be deployed or we believe that they're going to be deployed, we try to file an application and get it served as quickly as possible before that happens. It's much easier that way. Now, serving someone who is overseas depends on exactly where they are. There's a law called the Hague Convention. Various countries are signatories to the Hague Convention. And within that document, there are procedures and policies set forth as to how service needs to take place in that particular country. Now, when we deal with non-Hague countries, it depends on what agreement has been made between the foreign country and the U.S. military with regard to service. Oftentimes, however, if there's an issue involving serving a service member with a legal document, we can always contact a commanding officer who can provide guidance.
What is the Service Members Civil Relief Act, or the SCRA?
The Service Members Civil Relief Act is a federal law that extends various protections to service members on active duty, including protecting them from default in court matters. Okay, and what that means is if a party fails to respond, the court may determine that they're in default and may proceed without their involvement. This is particularly difficult with service members who may be stationed overseas, and that's why this law was created. It can provide various protections, including a stay of the proceedings for a certain period of time until the service member has the ability to deal with the issue at hand.
Can anyone oppose this stay?
The stay can be opposed. The service member or their representative, oftentimes an attorney, must request the stay officially, and a stay can be opposed with proof that whatever's happening in the service member's life really is not as serious as they make it out to be, and does not preclude them from being involved in the process.
Now let's move on to child custody and parenting time. Can you explain to us a little about which law governs in New Jersey and what New Jersey courts favor?
So the law in New Jersey really talks about, when we get down to the core of it, what's in the best interests of the child. The statute that controls, NJSA 9:2-4, sets forth various factors, but if you sit down and review them and read them and look at the case law that's been created, ultimately the court is required to make determinations in the child's best interest. With that being said, New Jersey favors frequent and continuing contact with both parents, and the parties themselves are encouraged. And the court even has built-in processes to allow the parties to make their own agreements that work for their specific family unit.
Now, can you explain to us a little bit about military family care plans and what that is?
So before we discuss the family care plans, it's important to note that the military does not allow single parents to enlist. In most cases, this also includes parents with joint physical custody. The concern being that a single parent who is deployed leaves behind a child with no one else to care for them. And parents who separate during their military service may end up as single military parents. And that's when we start talking about a family care plan. Okay, the family care plan can't conflict with any court orders. So if there's a court order that says defendant, whether it be the mother or father, can only have supervised contact with the child, the family care plan cannot give that party custody of the child in the service member's absence. And that's really what the family care plan is about. It sets forth who would take care of this child if the service member is not available to do so.
Are there timing requirements of when a family care plan needs to be submitted?
Absolutely. Service members are required to notify their commander, supervisor, or designated representative no later than 30 days following an occurrence that creates a single parent or military couple with children status. In the case of National Guard or the Reserves, it's 60 days. And within 60 days, 90 days for the Guard or Reserves, the service member must submit a family care plan. And active service members who move from one military base to another have 60 days to find a short-term care provider within that local area.
Do all branches have the same requirements for the family care plan?
Each branch has its own requirements, but there are three basic components. First, we have to designate a short-term care provider. That's somebody who can pick up the child immediately, usually within a certain distance, a few hours, and can care for that child on an immediate basis if needed. Then we have a long-term caregiver or provider. And this is someone who's going to agree in writing to provide long-term care for the children if the service member is deployed for a significant period or is selected for an unaccompanied overseas tour or assigned to a ship at sea. This person does not have to live in the local area, but the family care plan has to be specific as to how care is going to be transferred from the short-term provider to the long-term provider, including detailed travel arrangements and how the travel is going to be paid for.
Is there anything else that's important to know about family care plans and what they should include?
Well, what's important to note is something that I mentioned a few moments ago. We have to consider what court orders exist and ensure that a family care plan does not go against what the terms of those orders are, and either the consent of any non-custodial parent or an explanation for the lack of that consent needs to be provided. We also need to ensure that all provisions are made for financial, medical, and legal support to ensure the security and the continuity of care for this child is included. We talked about the fact that we need to have detailed logistical arrangements. We need to provide for how expenses are going to be paid. It really is a very detailed document that needs to be created with a lot of care.
Let's talk a little bit about parenting during service-related absences. Now, it's my understanding that New Jersey enacted a law in 2013 to address the need for special flexibility in child custody arrangements and parenting plans when one or both parents are in service. Is that correct?
That's absolutely correct. First and foremost, it's important to note that New Jersey law is very clear in that a service member's deployment cannot be considered as a substantial change in circumstance under New Jersey law that would allow for a more permanent change in custody. Basically, what that means is in order to modify a custody arrangement in New Jersey, a parent needs to show that something's changed, there's been some significant change that makes it appropriate and makes it in the child's best interest to modify the pre-existing court order with regard to custody. It's now become clear that the non-service member can't go into court and say, well, they're deployed, and that's my change in circumstance. Okay? That's not permitted to happen while a service member is absent for 30 days or more due to deployment or treatment for a service-related health condition. And once the service member returns, the court cannot enter a permanent change in custody order for at least 90 days.
What about parents' responsibilities? Are there any responsibilities of the parents?
Parents are required to advise the other of any anticipated absence dates and location no later than the day before departure or the 10th day following the receipt of their official notice, whichever one is earlier. The non-departing parent then must facilitate communication, electronic, telephonic, between the child and the absent parent, and oftentimes would be required to, if possible, ensure that the departing parent, the deployed parent, has the opportunity to visit with the child before they leave.
Now, are these temporary changes?
These are all temporary changes. As we discussed just a few moments ago, the court is precluded from making any permanent changes until a period of 90 days has passed from the service member's return from deployment or return from treatment for service-related injuries. So, in addition to that, these orders must provide for the deployed or departing parents exercise parenting time during their leave, and the orders are supposed to expire automatically when the parent returns home.
Now let's talk a little bit about enhanced flexibility. Does a child automatically stay with the non-departing parent?
Not necessarily. If for some reason the court believes it's in the child's best interest to remain with someone else, the court does have that option. Remember, we discussed that ultimately the court in New Jersey is most concerned about the child's best interest and what they determine is most appropriate for this child.
What factors does a court consider in determining appropriate modifications?
Well, again, the courts really consider what's in the child's best interest. They consider, which parent has been the primary caretaker for the child. It may be appropriate for the primary caretaker to take the child along on a deployment if possible, in which case the court considers what's going on in that other country. What provisions are there for that child over there? Is this an opportunity for the child to be exposed to another culture, which may benefit them later in life? Oftentimes, when we talk about deployments overseas, there are U.S. military bases there, which provide child care facilities, sports teams, extracurricular activities, and even an American school for the children to attend. In addition, the court also needs to consider what type of arrangements the other parent or an alternate caregiver can provide for the child. And it's really the totality of all of this information and all of these circumstances that allow the court to make a good determination about what's best for that particular child in that particular situation.
If a parent is facing imminent deployment, can a request be made to get an expedited date without waiving rights or requests to request a stay under the SCRA?
Absolutely. If a parent is aware that or becomes aware that they're facing a deployment that's going to take place in a very short period of time, or they're going to be experiencing some sort of treatment-related absence that's going to prevent them from appearing in court at a hearing or some type of an evaluation, they can make a request for an expedited date to occur before the deployment without waiving any rights that they may have to request a stay under the SCRA.
Now let's move on and talk a little bit about child support. What governs payment of child support in New Jersey?
Again, payment of child support in New Jersey is covered by statute, NJSA 2A:34-23. There are some additional guidelines that are imposed by the court rules. And as we spoke about in the very beginning, when there is a state court order, that is what controls, both for custody and parenting time issues, as well as child support. When there is no state court order, however, and no agreement between the parties, each branch of the military has their own guidelines that are followed.
Can you explain a little bit about military branch assistance regarding voluntary support allotments?
So if a service member wishes to voluntarily acknowledge paternity and provide financial support, their command can assist them in doing so by obtaining the appropriate available housing and dependent allowance. They can help you complete a voluntary allotment for the child, obtain a military ID card, and as well as getting some leave time to marry the child's other parent.
Does each branch have a different rule for these allotments?
Yes, they do. There's some commonality in that we're talking about a percentage of pay or a fraction of pay oftentimes, but each branch of the military's rules are a bit different. For example, when you look at the U.S. Navy, support is paid in different fractions. So if there's a spouse, the spouse gets a third of the service member's gross pay. If there's a spouse and a child, there's 1/2 that's paid. But one commonality all throughout is any support that is being paid is calculated based upon the service member's gross pay, which does include BAH and BAS, any hazard pay, parachute pay, anything like that. That's all included.
Okay. So what's the policy for the Marine Corps?
The Marine Corps, similarly to the Navy, bases the support on the number of dependents that any given service member has. If a service member in the Marine Corps is receiving a large BAH, that may be taken into consideration instead of just the service member's base pay.
Can you tell us a little bit about the U.S. Army?
The Army's regulations are a little bit looser. There are some minimum support requirements, but it varies depending on the living arrangements of the service member and the military or non-military status of the spouse.
What about the U.S. Coast Guard?
The Coast Guard calculates support as a percentage of base pay according to the number of dependents, also factoring in differences in housing allowances with or without dependents as well.
And the U.S. Air Force?
The Air Force basically says you need to provide adequate support and leaves it at that. So it's really a case-by-case basis as to what is determined to be adequate. Oftentimes it's something that is discussed with the service member's command, and a lot of times the parties will come to an agreement as to what they believe to be adequate.
Now, are these voluntary allocations under the branch regulations, are those enforceable in court?
They are not enforceable in court without a child support order.
And what if paternity is an issue?
If paternity is an issue, the father can be required to have genetic testing done. And that's something that a mother can request in the context of the court proceeding.
And why is this important?
Establishing paternity for a child is crucial in that it gives this child certain legal rights, such as rights of inheritance, health coverage, other benefits like Social Security, pensions, and veterans benefits. It's also important when we talk about custody and visitation rights, as well as child support. If we can't establish paternity for a child, we can't ensure that that child is receiving the appropriate amount of financial support from their father.
Now, I know you talked about this a little bit earlier, and you indicated that a lot of military income is available to determine the support. Can you just explain to us what specific military income is used to determine support?
Absolutely. People who are familiar with a military LES, which is a leave and earning statement similar to a regular pay stub in the civilian world. No, everything is kind of broken down. We've got basic pay, there's special pay, there's also basic allowance for housing, basic allowance for sustenance. And then depending on the service member's job in the military, or even where they happen to be located, there are additional forms of pay that they may be receiving, such as jump pay, flight pay, hazard pay. If a service member is stationed in a foreign country, there may be a cost of living adjustment. We oftentimes see this when someone's stationed in Europe because the cost of living is so much higher. They receive an additional amount of pay to assist in compensating for that. All of this is available for support for dependents.
Now, when there are child support orders and service members are called into active duty, should they notify the local child support office regarding their active duty, where their address is, what military branch they're in?
Absolutely. The best rule of thumb to follow is if you have a child support order and something in your life changes, your address, your job, your phone number, keep in touch with the local child support office and let them know. It's your obligation to do so. Even more so when we have a service member who's responsible for the payment of support, that support oftentimes is garnished directly from the wages. And if there are going to be modifications, the child support office needs to know about them so they can ensure that the garnishment continues and a child is not required to go without sufficient financial support.
Now, if a service member gets deployed, and I guess it's possible that their income could go up because maybe they get some hazard pay or some jump pay, is that a situation which would create a change that could have child support revisited?
It absolutely can. And oftentimes, we look at it kind of on a practical basis and say, well, how long is this anticipated to last? If there's going to be a 1 month period of time where there may be some, small amount of extra pay in the service member's check, more likely, rather than filing an application for a child support modification, which can take a month and a half, 2 months, perhaps even longer if the SCRA is involved, it may be more appropriate to reach out to that service member directly and say, hey, we know that you're going overseas for 2 months on a special assignment and you're likely to be receiving an increase in your pay. Let's take a look at child support and see if it should be modified, in the interim. In the event that this is anticipated to be more of a long-term change, what we would do is file an application with the court to request that we modify child support accordingly.
Can child support be enforced even if a service member is on active duty?
Absolutely. And even sometimes if a service member is deployed and they're trying to stay proceedings, if there's a court order in place for child support to be paid and the court determines that the other parent has been notified, they're aware of the order, and the custodial parent, the person receiving the support, is trying to enforce that application or that order rather, the court can continue a temporary support award, even if a service member is attempting to stay the proceedings.
And are there other remedies for enforcement that can happen if not paying support?
Absolutely. And these additional remedies apply to service members and non-service members alike. The IRS can intercept a federal income tax return and send that money to the Child Support Enforcement Agency. There can be liens placed on real or personal property. The person's bank accounts can be levied. Their driver's license, professional licenses, even a fishing license can be suspended for failure to pay child support. A civilian passport can be denied. People can be reported to the credit agencies. And ultimately, if we really have a significant case of enforcement, a warrant for someone's arrest can be issued.
Now, can wages be garnished of a service member?
Absolutely. Branch regulations require service members to honor support orders. And each branch of the military has its own wage garnishment procedures. There's also a federal statutory allotment procedure specially designed for military obligors. Service member receives advance notice of implementation, and within the first 30 days after notice will be offered an in-person consultation with a judge advocate or legal assistance officer to address any arrearage that's been accumulated.
Can these orders, would they be enforced in other states?
Absolutely. Once a child support order has been entered, there's a procedure under UIFSA, the Uniform Interstate Family Support Act that we spoke about in the beginning, to file that court order in a second state where the obligor, the person paying the support, may have income or assets. The parents will receive notice of the registration. They'll have the opportunity to file any application that they deem necessary, but absolutely.
Right. Let's finally talk about some military benefits for the children. What is the Defense Enrollment Eligibility Reporting System?
So that's commonly referred to as DEERS, and it's a computerized system that keeps track of all recipients entitled to military benefits. And again, this is one of the reasons we need to have a determination of paternity, because all of a service member's dependent children, whether they live with the service member or not, are eligible to register with DEERS, provided that a military installation with an ID card issuance site has determined that the child relies on the service member for more than 50% of their financial support.
Now, how do you enroll a child into DEERS?
There are a few documents that are required, including a certified copy of the child's birth certificate, and if paternity is an issue, a copy of the paternity order or signed acknowledgement of paternity form. A non-military custodial parent can also enroll a child into DEERS by contacting a military installation unit with a particular ID card issuing facility in the same service branch as the military parent. They simply need to show documentation proving the child's eligibility and the military parent's social security number.
Now, once a child is enrolled in DEERS, can they get medical treatment in a military facility or a civilian hospital?
Absolutely. They become eligible to receive treatment under TRICARE. Children under the age of 10 can simply use their parent's ID card, but all children should have their own card if they don't live with the service member.
Rachel, thank you so much for all this information that you've provided us today. If you're looking for any more information, please refer to the websites we provided or reach out to an attorney to get specific answers as to your issues.